Hello, everyone. Good morning or afternoon, depending on where you are joining us today. I want to start off by saying thanks so much for being here and spending this hour with you. We know your time is very valuable, so we really appreciate it and want to welcome you to our webinar. Before we get started, I want to make sure everyone can hear me all right. So if you could please just make a little note in the questions tab of your GoToWebinar panel, just to make sure audio is coming through here. And then we'll get started. Great, looks like it's working. So let's kick it off. And we are excited today. We have some great information and some great guests today who you guys will really like. But I want to say before we start that this afternoon you will receive a copy of the slides, a recording of the presentation, and your CEU certificate for 1.2 CEUs. We are very happy to share that with you, and just be on the lookout this afternoon for those resources. Please feel free to share the slides or the recording with whoever in your organization you think may benefit from that. So a little bit about today's presenters. If this is your first webinar, you'll recognize, or you won't recognize anyone, but if this is a repeat, if this is second or third or maybe even sixth webinar for you, you'll recognize Mike Rosen and Donna Thiel. Mike is our co-founder and fearless leader here at Provider Trust. He has 30+ years experience in background checking and is has been a legal advisor to compliance and HR departments throughout his career. We are very happy to have Neil Evans from Lane Powell with us today. Neil also has around 30 years experience. He served as an assistant U.S. attorney at the Oregon U.S. Attorney's Office. His legal practice focused on affirmative civil litigation and criminal prosecutions, including white-collar prosecutions, healthcare compliance and fraud, environmental matters, and recovery of federal program funds on behalf of all federal agencies. And Neil joined Lane Powell's Compliance and Investigations Unit last June. So we're very happy to have him today. And Donna Thiel, our Chief Compliance Officer with 30+ years experience in as a compliance officer for large health systems across the nation. So you guys really have a who's who of who can speak to this topic today. So moving on, a little bit about us. We are Provider Trust, located here in Nashville, Tennessee. We help compliance and HR professionals streamline some of those processes that are tedious and time consuming, really regarding exclusions, license monitoring, and sanction screening. We are happy to share these webinars with you. Part of our culture here at Provider Trust is we love to help others grow and succeed. So we want to join together with all of the HR and compliance professionals, learn together about these relevant topics, and then grow. So just one more time, just want to say thanks so much for joining us today, and we're happy to share. So a little bit about today's agenda. We'll start off with Internal Investigations 101, then we'll move to Internal Investigation Techniques, then into Internal Investigations, how to get started at your organization. Then we'll talk about some outside counsel considerations, and finally we will wrap up with takeaways. So before we start, I want to know a little bit about who we may have on the call. So I'll launch this poll. This is our first of 2 polls today. So we have HR, compliance, legal and risk, or other. And I'll ask that if you do choose other, please just write in the questions tab what department that may be, because we're interested in who joins these calls and who finds value in it. So we'll just leave that open for just a little more time and close and share. So compliance, thanks for showing out today. We're happy with everyone being here on the call. HR, about 18% of folks, but the overall majority here in compliance. Legal and risk, we're happy to have you. And again, if you did choose other, please just specify in the questions tab, just so we can kind of keep tabs on who's joining our calls. So with that, I will pass it on to Mike Rosen.
Thanks, Matt. I hope everyone's coming off of a very nice holiday weekend. And for anyone on the call who is an active vet or has served in the military or family, thank you. It's unfortunate, I think this holiday has gotten lost in just the beginning of summer and not really remembering what's important, and that is those who have served. So thank you for that. All right, we're going to talk today and cover some ground, so I want to get right into it. This is a really important topic, and we hope to be able to impart upon you some new ideas and or to solidify some things that you may already be doing, and to prove that the importance of conducting a very good, thorough, and effective internal investigation. So we are talking internal investigation, not external investigations, and that there is a difference. So if you do have questions, though, and you feel like it is regarding something that might involve an external investigation, we do have Neil's 30 years experience with the prosecutor's office that he could maybe impart some knowledge, but we're hoping that from his perspective, he can share really the importance of an internal investigation from the standpoint of once the government gets involved, where does that help you as a leg up? And I think one of the things you're gonna hear from him, besides the attorney-client privilege that can be gained by using outside counsel to do an internal investigation, or even some of the federal sentencing guideline reductions in penalties by doing certain things right. So, this stems really from a duty that the corporation has to investigate a matter that's brought before it, or that it uncovers, however that comes to light. And really, I like to look at this concept as suggesting that you do so appropriately with both open ears, open eyes, and don't go in with a preconceived notion as to who may have done something or looking for something. Your job is not that. It is to uncover the facts and then to have applied against the law or policy at your company what that might mean as a going forward step. So lastly, I think it's important from an overall standpoint to remember that you're really certainly not there to cover something up. That's not your job. So for all of you in compliance, in which you've got to make sure every stone is unturned and decide then from those facts what to do, going into it that it's not advisable or legal really to try to cover stuff up, but instead to figure out what you've got to deal with. So by doing so, you're going to reveal all the relevant facts, and you owe those to someone in the organization, whether that is your board, your management team. If you've got a board that has a compliance committee, it may very well go to that level. And in some cases, it may not rise to that level whatsoever, but it does provide the corporation with some advantages and defenses by doing this correctly. So let's start out by saying that the things you need to really consider is, do you need a formal investigation to complete what has been raised? And that may seem like counterintuitive, but not all of the investigative or all of the measures that are brought to you will require an internal investigation, at least not a formal one, but a lot and most probably will. And what we're thinking about there is some example or some of the hotline items that come your way may very well be dealt with appropriately through a less formal internal investigation directly by a department or somebody with knowledge of how to handle it. But something like sexual harassment or other issues may very well rise to a different level. So some of the problems need to be resolved and reported, but they need to be done efficiently and as quickly as possible so as you can preserve facts and evidence that is relevant to the matter. And then I think it's important that you don't forget, what does your company policy say about this? And if it doesn't, do you need to have a policy that addresses internal investigations? I think you do, and I think you probably do have one, but worth taking a look at so that you don't violate your own policy when conducting an investigation. All right, so what could trigger an internal investigation? Well, lots of things can. We tried to take a few of the bigger ones, but certainly, you might even stem from an internal audit that comes about from either a third party or your own processes in looking at your compliance. And as a result, there needs to be follow-up and remediation potentially. Clearly hotlines and or employees bringing things to the, or even from a third party perspective to the organization is equally important. Don't forget though that even matters of involving a licensure or an exclusion of a provider requires some form of documentation and internal investigation. There are reportings that you would want to do, self-disclosures, things of that nature, or fines you may have to pay as a result, but not to be forgotten. And clearly, always follow with interest. We do, and I suggest someone on your team is familiar with what the OIG, the Department of Justice, or even CMS is saying about this. Sometimes they're putting out guidance in this regard. There's quite a bit of coverage in this area on the OIG site in what boards should be doing and conducting investigations, et cetera. And lots of law firms like Lane Powell and others have white papers on this and checklists and things of that nature. Now, if it rises to the level of the last one, I think Neil probably has the best voice on this. But if you receive a search warrant, a criminal investigation complaint, or an investigative subpoena, it rises to a whole different level and clearly takes us beyond not just a need for an internal investigation, but probably an outside counsel pretty quickly. So we talked about some of the examples that compliance being 80% of who's on this call today might face with, and this could stem from billing, overpayments, documentation that's falsified, medical record things, drug diversion. These are pretty serious allegations that need to be documented. But then HR, you guys are equally as important to this, and things involving sexual harassment, hostile work environment, any kind of discrimination is not to be taken lightly, and certainly warrants a very thorough investigation. So what's the purpose of an internal investigation? Before I round out this section and turn it over to Neil and Donna, I think really if we boiled it down to, it helps determine if the allegations that have been raised have merit. You're a fact finder in an internal investigation first and foremost. And so you've got to determine what are those facts, and then ultimately rely upon guidance and counsel on what to do or what that may have violated, if anything. Sometimes it can be simply remediated and documented and you're fine. And other times it rises to a different level of oversight. So be mindful of that and evaluate or seek advice from your in-house or outside counsel on regulatory other matters. You certainly don't want to be faced with something that is, from the government's perspective, looks like it's a cover-up. And we've seen some cases in which the department now is going after, Department of Justice is going after the compliance officer personally if they find that there was knowing violations. So this is a serious measure to be taken. You want to make sure that you're both accessing and discussing options for what the response might be as a team and getting consensus on what that should be, and then taking the action if there is any that would warrant best practice for next step. So prior to taking any of those actions, you got to decide, was there an official complainant? How did this come about? Did somebody individually report to a hotline? Did you receive something directly from an insider, somebody that felt that they want to make sure that it is known to the corporation, but they need their identity protected, and you need to do everything in your power to do so in protecting their identity? Does physical evidence exist? Interviews are going to determine that. Video cameras, is there documentation? Are there things that you need to do? I think Neil will talk a little bit later about the preservation of documents. If it rises to the level at some point in which counsel says you're going to need to send out, somebody on your behalf is going to need to send an email that you can't destroy any evidence, any documentation, because we've now uncovered a potential SEC violation or a potential, OIG problem, and we need to preserve all the documentation electronically. So you don't want anything tampered with or anything that would put you in bad light when the government does show up. The other points here I think are self-explanatory, and really determining the scope of the investigation is something that will be discussed in a little bit more detail by Neil. Rounding this out, scope is important. You need to determine and think this through in advance. This is not the time to show up unprepared and sort of see where it goes, because you need to know what documents you suspect you need to look at. You need to be listening for ones you didn't think of, and you need to be adding to your list interviewees that you might not originally have thought, but learned need to be talked to. And then decide whether this can be done internally or as we've said, through really needs outside counsel. In looking at the scope, here's the basic who, when, how that needs to be outlined, really kind of the beginning of a checklist for you. And then for each person that falls in that category, it would be advisable to come up with specific questions in advance you'd like to know, as well as documents you think that they may be in possession of, so that you're informed. And then what not to do? Well, don't ignore it. This is not the time to pretend like it's going to go away if you don't pay attention to it. And in fact, a lot of the key TAM actions statistically come when the complainant didn't think anyone listened to them, so they just went straight to the government. And that's a win-win for the government, but not a great place for you to start. Don't defend the accused. You're not there to judge. You're there to obtain facts and determine what may or may not have happened. You do need to maintain the confidentiality of this throughout the organization, throughout the time frame, and follow reasonable investigative techniques, as well as document and preserve all of the evidence. So these are the things that kind of round out. And what I'd like to do is turn it over then to Neil to talk about some of the characteristics of an effective internal investigation. But first, we're going to do another polling question. Thanks, Mike.
So this is our second poll of the day and our last poll of the day. So just thanks for participating here. We're just interested in who has experience with this on the call.
Oh, have you been involved personally in an internal investigation? I'm sorry. So either yes, you have, or no, you haven't. And we'd like to know sort of the audience and the spectrum of experiences. So simple yes or no.
Great, so we'll close that out and share.
Oh, wow, 80% of you have, but almost a third have not. So that's good. We've got some pros, hopefully, and some that we'll be learning for the first time, maybe the best way to do this. So Neil, we'll turn that over to you now.
Okay, thank you. And Donna and Mike, feel free to chime in based on your experience on any of these points. And I don't necessarily want to read from these PowerPoint slides, but you should know that the investigation, it will be to protect the interest of the company and find out, as Mike says, the actual facts behind the complaint. And so in protecting the interest of the company, you want to look at the company policy, the guidance that might have been provided, as Mike mentioned, and define the scope based on the complaint. And that'll become, the importance of that will become more clear later when we talk about the attorney-client privilege. So you do want to prevent and detect misconduct and violations. One, it's the right thing to do. Two, it's good for morale, and just generally you want a work environment that is free of misconduct and violations. And obviously your corporate activities want to comply with the existing law. I've got a case now involving the Alaska Medicaid office, and there's some accusation that corporate headquarters should have known about the rules and regulations involved. And in fact, what happened is we had kind of a rogue employee up in at a certain location that was doing things to kind of self-promote himself, and it wasn't in compliance with the applicable laws and regulations, and yet the corporation is now being viewed as potentially committing some fraud. So you certainly want your stakeholders and the people active in whatever activity you're doing to be aware of and understand the importance of complying with the laws and regulations. And then I think a component of any good compliance program, as you all probably know, is, are you going to take action based on the problems that has been raised? So can you identify areas for improvement? Do you need a more stringent compliance program? Do you need, just a little more direction, a little more guidance in one particular area because that has created this other problem? So the organizational goals, the next slide, is to minimize the business risk, both just internally in terms of your business, but also your risk of a government investigation, False Claims Act, obviously treble damages, high level of penalties. Criminal conduct or criminal action is always possible, although thankfully not very frequent. You want to identify the weaknesses in the business operations like we talked about or just mentioned. If you've got a compliance issue and there's room for improvement, that's a weakness that you need to, take some steps to remedy. And if there's a particular employee, like in the instance I just talked about, as it turns out, that employee was fired about 4 months into his tenure with the company, and that is right about the time where the improper billings stopped. And so I am now able to argue on behalf of this company that, we terminated this bad employee. It might not have been exactly for the conduct that's under investigation, but certainly it was related conduct, and the person has been terminated. To the extent that company assets have been lost, you want to try and recover those. To the extent that there's a government loss in a Medicare or Medicaid program or in a local program, certainly the government is going to be asking for that money back. And I think part of the job is understanding all of the facts and the level of corporate culpability to perhaps argue against the False Claims Act argument provides the government a multiplier of damages. And their bar, when I was with the government, the bar is fairly low. It's preponderance of the evidence and did the company act in reckless disregard. And so during a lot of if the government's involved and if there's a potential False Claims Act action, one of the things that you need to investigate is was the company put on notice? Were individual employees put on notice? What were the CMS guidelines? What other public information is out there that will provide the government an argument that you knew or should have known about this rule or regulation that is potentially violated? And that flows right into prepare for anticipated civil or criminal litigation involving the company, right? I think you've always got to keep an eye on that, even though it seems like it may seem at the outset like a purely internal matter. I think one of the questions, and maybe even the complainant or the victim didn't mention exposure on the government side. I think one of the things you need to look at is, if all these facts are accurate, is there some impact beyond, maybe an internal employee matter or an internal business problem? Did that false statement or did that problem manifest itself in a potential false statement to the government? So at least ask that question. So as Mike has said, the effective investigations will determine, what happened factually, if the suspected conduct did or did not take place, who was involved, was there a violation of the law or the company policy, and what steps need to be taken internally, like I said, corrective action, employee discipline, or external action, self-report, pay back some money. And there are certainly some benefits to self-reporting and paying back money. There are also some risks involved in that, and it's always for me now being in private practice, it's a difficult question to answer as to whether or not you absolutely should self-report. There are some things that the answer is very clear. There are other times when it's more of a gray area, and it could just be a simple overpayment matter. It could be some fraud, and so you really have to examine the facts. And I think as compliance officers, there's a few folks in the legal arena. Your job is to, and there's some folks in HR, I think you've probably experienced this, which is, look, you need to determine the facts. You can make a recommendation, but ultimately it's going to be management or maybe even in-house counsel. They're going to make the decision on what happens, what remediation is needed as a result of those facts. I always thought it was problematic when my HHS OIG agents would see some stats early on in an investigation, they'd essentially make an internal determination that this involved fraud, and that drove their investigation, the way they approached people, the way they looked at documents, and that can be problematic. So again, reiterating what Mike said, you're not necessarily you're not there to pass judgment. You're there to determine the facts. You can certainly have an opinion based on those facts, and you can certainly make a recommendation, but I would just be wary of coming to premature conclusions without some factual support, because oftentimes that can, drive your investigation in one direction or another, which, ties in nicely with the characteristics of a good investigator. You want to be confident, professional, independent, and unbiased, which is what I was just addressing. And I think it's good to be a little skeptical. Don't assume you're being told the truth. As an old lawyer, I can now look back and think, as a young lawyer, I always thought people were telling me the truth. That's what people do. That's not necessarily the case. And you need to think about that when you're going into interviews, reviewing documents, and which ties in with understand how to ask the right questions and understand the organization's policies and procedures. And I think it's really important to, before you start, and we'll talk about this a little bit more later, before you start conducting interviews, I think Donna here is going to talk about having a plan and think about how you're going to approach this, is gather as many facts as you can. As a government prosecutor, I would go to CMS and get stats. I'd look at public records that were available. I'd find out whether there'd been any administrative action against an entity I might have been looking at. I'd get as much of that information as possible before actually I even started requesting records. Because then you need to know what you're asking for, and you need to look through those records, and then you will be prepared to start doing some interviews. And I think that ties in nicely now, Donna, with going to creating a plan for an internal investigation.
Thanks, Neil. Thanks, Mike. And good afternoon, everyone. Nice to see so many familiar names on our attendee list this week. Nice to talk with all of you. So let's talk a little bit more in detail now about actually starting our internal investigation. And as Neil and Mike have both alluded to, creating the plan is really important. And I think as you look at investigations, are you doing, whether you're doing a full-blown internal investigation, or if you're doing just some follow-up on a hotline call, a plan is really important, I think, as you get started. So first, you need to sit down and think about, what do I know? As Neil alluded to, what are all the facts? Collecting all of the facts that have been given to you so far. Really figuring out, are there documents that relate to the inquiry or the investigation that you're about to undertake? And not only identifying what those documents are, but in my mind, where are they? Are they documents that I can get if in my world, I was part of a large post-acute provider. So we had nursing homes across the country. So we had certain things that were accessible to us at the corporate office, but then there were other documents that could only be retrieved on site in one of the nursing facilities. So understanding what's the best way. Is it better for me to try to gather the things corporately, or do I need to send someone to a location to gather those documents? Can I ask someone at the facility? Really understanding the what and the how relative to the documents are equally as important. Then, of course, thinking about, who do I need to talk to? Again, there's all sorts of different folks that are probably going to be involved. Thinking about the who, and then what's not on here is who's the interview list, but who are the interviewers? We're going to talk about that in a couple of slides, but really thinking about who's the best person in the organization, whether it's an internal resource or do you need to go outside and have some outside counsel or other third party helping you with the interviews and the investigation. We're going to talk a little bit about what good questions look like, but really thinking about what those questions, at least categorically, what are the questions that I'm going to have as I go through this investigation. And then I always like to kind of have some sort of a timeline, certainly not to the degree of I'm going to be completed with this in 3 days or 7 days or 10 days, but kind of what's the flow? How does my timeline need to look as I'm putting my overall arching plan together? So let's talk a little bit about developing those interview questions that we just mentioned. So first and foremost, you absolutely have to have your questions prepared in advance. Don't think that you're going to walk into an interview and just be off the cuff. That's the worst possible thing. You need to have a plan. What's the sequence of the questions? Make sure that they're really well designed. Think about the words in each of your questions. And really, in my mind, you need to write them down, create that list, put it on paper, have it in front of you. And certainly, as you're going to get an answer that's going to drive you perhaps to a different question than what you anticipated, but you should have a flow and have all of your questions organized. And even consider having either a colleague who's familiar with the scenario review your questions, or if it's a really important investigation and interview, maybe even just do a quick practice. I certainly had outside counsel that I've worked with many times. Actually, my favorite outside counsel is Barb Duffy at Lane Powell, and she was just amazing at helping me put questions together and really making sure that my questions were well thought out ahead of time. So always think about outside parties that can help you in that creation as well. So once I've started, right, I'm in my interview, I have all these notes, and I don't think you can undervalue, if you will, the importance of taking your notes and thinking about how they should look and feel. Now, I oftentimes would go back to my notes after an interview and during the interview thinking, oh gosh, I just took great notes. I'm going to really be able to remember. And then I would look at these notes and they were cryptic, and I'd have to supplement them and put secondary notes on top of it because I couldn't, when just by reading them at face value just didn't give me the same story that I knew I had in my head. So making sure that your notes are thorough. And while you're taking the notes during the interview, sometimes just being able to slow the interview down and being able to say, please just give me another minute while I complete my notes. It gives you time to take a deep breath, make sure you're staying on task, and that you're following your own plan going into it. So maybe a side benefit of just being able to slow things down a tish as you're taking your notes. And I think, Neil, if you don't mind, maybe just explain a little bit to our listeners today on the value of the role of the person that you're interviewing and whether or not you should be having them sign off on certain statements that you're taking during the interview, and just kind of that decision point relative to the notes that are being taken and the statements that are being taken during the interview process.
Yeah, exactly. I don't think it's necessary for the witness to sign off on your notes. Certainly with the government, we didn't have the FBI or OIG agent have a witness adopt those statements, but it's important if there is something that's critical to your investigation or 2 or 3 points, and you think you've made it clear, without unnecessarily highlighting that the witness is just giving you some critical piece of information, don't be afraid to circle back with them at some point and, say something like, look, did I understand correctly? What I heard you say is, and maybe you've got a document to show them, and just say, look, I just want to confirm that this was your statement. I think that emphasizes the point Donna was making, is that while the notes are clear to you at the time, a day later or maybe even that afternoon, you can look at those notes and think, I'm not sure I made that point, or that's the answer I got. And trust me, there is nothing worse than going back and looking at a transcript of a criminal proceeding where you think you've nailed somebody and you think, maybe I could have asked a better question than that. And you leave room for the witness to wiggle out, if you will, of an answer that you thought was pretty good and provided you the information that you needed. So don't be afraid to go back, like I say, and just get them to confirm some critical pieces of information that you've obtained during that interview.
Excellent. Thanks, Neil. So let's just move on to our next slide and talk a little bit about interview techniques. So I'm sure Neil would agree with this. You should always have a second person with you when you're conducting an interview. You always want someone to help you take notes, to just corroborate the information that you gathered, and certainly sometimes from a safety perspective, having a second person in the room if things escalate or get out of hand. So it's important to think about who that person is, and we have a slide in a little bit that talks about notification of supervisors and things, but as you're thinking about interviewing and having a second person, is it someone, if you're from the compliance department, is it someone else from compliance? Is it someone from legal or HR? Typically is not someone directly related to the person you're interviewing from a supervisory perspective or coworker perspective. Should be someone that is comfortable in that setting. I think always a good goal is to develop a rapport with the person that you're interviewing. That doesn't mean you need to be their best friend, but you are trying to get them to disclose information, and you need them to trust you, that you're going to listen, and you're going to be fair, and you're going to gather the facts as they're presented. So figuring out the best way for you to develop that rapport, in my opinion, is very important. Certainly asking open-ended questions, right? You don't want to ask questions that are simply yes or no. You want them to feel a need to tell you a story. Hopefully you craft your questions in such a way that the person has to think a little bit, that they really do have to expand upon the information in order to give you context or background. Asking the questions in a logical sequence. This goes back to that original plan, right? As you're sitting down and you're thinking about what information do I need to gather first, second, and third, your questions should follow that same sequence. We also talk about the importance of the order of which you're interviewing people. You need to start that with the person that probably has the least information. You're just going to gather a couple nuggets that drive you to the next person that will give you a little bit more information, and ultimately brings you to the person that has the most knowledge, or maybe is the subject of the investigation, gathering lots of information. So sequencing is always really important. And this one, the next one, allowing for silence, I'll be honest with you, that one is really hard for me. Some of you who know me well, I like to talk, I like to ask questions. I'm an okay listener, I'm not a great listener, something I always am trying to get better at. But generally speaking, the interviewer should be only talking about 20% of the time, right? So you're asking a question, you have to be comfortable with that silence. Usually the person that's being interviewed is uncomfortable with the silence, and because of that, they have a tendency to tell you more. So just being patient and being a good listener and being okay with that awkward silence is really important. And then certainly, again, kind of with on the same lines as the importance of rapport, just give them a chance to explain their answer. If they're uncomfortable with why they did something or why something happened, again, be that listener, let them explain, because again, the more they explain, the more color it adds to the information and better understanding probably for you as the interviewer. So some important techniques. So now when we talk about scheduling these interviews, this is really, in my opinion, incident specific, if you will. So there is no right or wrong answer. It all depends upon what you're investigating and really who the interview is with. So generally, you would typically notify the supervisor in advance of the interview. You would notify the interviewee, right? You would schedule the interview and you would have a comfortable time, an agreed upon time where everyone's available, and you would go on site or you would have it over the phone. Again, just depends on the severity, if you will, and the importance of the interview. But there are certain, excuse me, there are certain mitigating factors that would potentially change that answer. If you have concerns that the person that you're interviewing could potentially destroy evidence or modify documentation, you would certainly not want to give them a heads up that you're going to that you're coming to chat with them about a particular situation or even potentially a document. Certainly, if you feel like a group of people, once one person finds out they're going to be interviewed, may go talk to 2 or 3 other people because there was a particular event and now they want to get their story straight, or they want to potentially intimidate someone into not answering questions or not answering truthfully. All of those things would be things that you definitely need to consider when you're deciding whether or not to schedule the interviews. The next 2 sections we want to talk about relative to the interview are certain techniques and differentiating between what we're calling the reporter, the person that brought this concern to your attention. Now, at the early onset of this webinar, Mike gave you a list of potential ways that an investigation could start. And clearly there are many that don't start with a specific person calling you, but you may still have a primary person in your organization who is a subject matter expert, who I would still consider falling in that kind of quote reporter. People who you don't have concern, at least at the onset, you don't have a concern that they may have been a bad actor or a contributor to whatever the investigation relates to. So someone that we would call a reporter. Reassure them that right off the bat, we are taking your concern seriously. One of the things that we all know can come out of a poorly managed investigation or a poorly managed complaint is a whistleblower. So right off the bat, if someone's coming to you, we know that they have a potential, there could be the potential that they would become a whistleblower if they don't feel the organization is taking them seriously. So first and foremost, immediately address that. Reassure them that you and your organization has a commitment to non-retaliation, that you won't stand for retaliation. We talked about one of the early things prior to even taking action is whether or not you need to protect the identity or protect the quote reporter. And then as you're thinking about just kind of what kind of questions, certainly all the basic who, what, where, when, why, or maybe they don't know the why. As you'll see, I didn't put why in that bullet, but who, what, where, when, and how, if they know the how. Encourage them to just give you as much information as they possibly can, down to whatever detail that they have, whether you think at that point in time it's important or not. And certainly encourage them to talk to you about what they have done in the past. Have they reported this concern to someone else? Has someone ignored the concern? Or have they just not been comfortable up until now reporting that to anyone? And if that's the case, that's meaningful information as well. And ask them, you know, who else do you think we should talk to? Is there somebody that you think has direct information about this particular situation? Ask them. They know best, right? They're bringing it to you. And then ask them if there's any documentation that they think that we should look at. Unfortunately, I've had many situations where I've received phone calls and I've spoken to people and they say, oh, I took copies of so-and-so's medical record just to prove to you that this happened. Or, oh, I've taken such and such a document from the facility because I wanted to safeguard it. And of course, there's a concern right there of, do we have a HIPAA violation? Do we have a policy violation for taking information or photocopying it? But making sure that we know what information that they have or what we should be looking at. is very important. So then let's talk about the subject, if you will, the person that we may, or at least initially, believe may be at the crux of this investigation. As I mentioned earlier, typically this would be the last person that you would want to interview. That might change based on the information that you get, but generally speaking, you're going to build up to this particular interview. Prior to starting that, absolutely positively gather as much information as you possibly can. Make sure you have all your I's dotted, T's crossed. You have documents in front of you that either presumably support the need to have this interview. And then, of course, you're asking them again to give you the facts, the who, the what, the when, the where, how, whatever it is that you can garner from them. Same sorts of questions. Have they talked to anybody about this in the past? Oftentimes when you're interviewing a subject, right, they're going to say, oh, I told this person and that person, and everybody's been doing this, or I don't see why it's a concern. They're going to likely point you in a lot of different directions, and being prepared to gather that information. And then if you are in a situation where, you know, either they've shared with you that yes, they did this, or you really are at a point where you absolutely, it seems to be clear that everything is pointing to this particular person, it's the why. Ask them why. Why, you know, why did this activity happen? So before we move into the last section of our webinar today, which is third-party considerations, I just want to share a story that kind of pulls, I think, all of this together when we think about the importance of preparing and the plan and thinking about the value of an investigation and how it's going to protect your organization. We had a very serious situation of theft. We had a business office manager who diverted resident funds for an extended period of time. And when it came to us, when we found out about it, we had to, when you think back about on the organizational goals of an investigation, like what are you trying to protect? We had to do this investigation in a manner that we were able to work with the local authorities from a prosecution perspective. We had all sorts of residents whose monies were stolen. We had to bring in third-party auditors to come in and look at the resident trust funds and try to help us figure out how this person diverted all these monies. There were so many schemes that were involved that were way out of my comfort level. So I had to utilize my internal audit team. I had to utilize our finance folks to help educate me on how all of the business office financial processing worked. Obviously, we used outside counsel to direct all of the investigation. So we had to gather information in a way that would protect us so that we could go after this person criminally. We weren't protecting ourselves. We were trying to protect the information and gather it in a fashion that the local authorities could use that information. So it's just an example of really pulling that plan together, understanding who the subject matters are, who the subject matter experts are in your organization, who can conduct those proper interviews. When does outside counsel need to clearly come in and guide you through this process so that you are not misstepping along the way? So I just wanted to share that example. It's a story that is ingrained in my brain. The facts, if ever we're having coffee or a cocktail, it's one of those stories that you can't make up. We all have had those scenarios, but when one that was a very interesting investigation, and one that took us almost 14 months to conclude by the time we unraveled all of the things and were able to hand it over to the prosecuting attorney. So with that, I will turn it over to Neil, because I do think having outside counsel and third parties involved are so important in these very serious investigations. So Neil, I'll turn it back to you.
Thank you, Donna. And those last points a nice lead into an effective investigation, and sometimes the need for an outside counsel. Outside counsel can sometimes bring a subject matter expertise, or they can certainly hire subject matter expertise, and that would potentially bring that work product under the attorney-client and work product privilege, which we'll talk about. Outside counsel oftentimes has some contacts. I mean, quite frankly, I've been retained here in Oregon because I know who the prosecutors are, I know how they think, I know what they're interested in, and it can be very effective. Sometimes the scope of the investigation, as Donna just said, that one was 14 months, involved a lot of information. The scope can just be too large for in-house counsel to handle. And finally, or at least a final point, is that you want that added layer of independence. You know, you don't necessarily want in-house counsel directing an investigation that ultimately could clear the corporation or the employees. You want the appearance, if not in actuality, the independence of an outside counsel. And one of the things that's important we've talked about is the attorney-client privilege and the work product privilege, and both of those protect information that's gathered during the investigation. And there are finer points to be made about that, but certainly the work product privilege is I'm sorry, I lost track of the slides. The first point on how to protect the attorney-client privilege, I think, also helps understand why defining the scope of your investigation is important, because in-house counsel often provides business advice, but they're not necessarily providing legal advice on potential litigation matters or on compliance matters. And so you want to be able to say, look, the scope of our investigation, the reason we hired counsel was to focus on this one complaint, and that's what we're doing. And so any interviews or any conversations, there should be some reasonable expectation that they're going to be kept confidential, that it covers the employees as well as the officers and directors and agents of the company when they're communicating with counsel. There's something called the Upjohn warnings, which arose from a Supreme Court case of Upjohn, which essentially says, look, if you're outside counsel and you're brought in, the best thing to do is to advise the individual employees that you are counsel for the company. You're the company's lawyers. And of course, all these witnesses probably want to say, am I in trouble? What's my exposure? Can you give me some legal advice? And the answer really is no, we can't provide you any legal advice. We are the lawyer for the company. At the same time, we're going to ask the individual employees to maintain the confidentiality of the questions and answers in the interview. And we don't want that employee talking to, their friends or their family, because arguably that waives the attorney-client privilege as to at least that interview. And then the work product, again, it protects documents and records and the thoughts of the lawyer. So if the lawyer is involved in the interviews that, Donna was just talking about, some of the facts, like when was this person hired, when were they fired, when did this happen, or when did that happen, those facts aren't necessarily protected by the work product privilege, but the impressions of the lawyer, if they're writing them down in the notes, even the impressions of the interviewee, if the lawyer's present and the interview's being conducted at the direction of the lawyer, those can be protected. And so it's important to maintain that confidentiality of the communications and of the work product, because all of that can be waived. And I think this is brought home by the next slide of best practices to maintain the privilege. Sorry, I skipped over the other one, Matt, but I think we're in good shape. So the investigation, as I've just said, should be directed by the attorney. It should be for the purpose of obtaining legal advice. It should be confidential and distribution limited. I'm sure you have all experienced in other settings, or maybe even in your compliance and HR settings, where you send out an email, or you're the recipient of an email, and you send it on to one person, and before you know it, that email chain just gets blown out of proportion and sent to people that had no business getting it, or you didn't want to have read it. And so that's a dangerous situation. I know, federal prosecutors these days, their phone message literally says to agents who are calling them, don't leave a message. This could be discoverable. This could waive some privilege. Don't send me an email discussing the facts of this case. And I think the same thing can be true in your world of compliance work, is just be careful what you're putting down in an email. Careful who you're talking to. You don't want to inadvertently waive that privilege. The last bullet point on best practices I made before, which is, look, if outside expertise is needed, whether it's an accountant or anybody else, if the lawyer hires them, then there's a pretty good argument that the outside expertise is work for the lawyer is protected by the work product privilege, and potentially the attorney-client. The best practices to maintain the privilege also include, I'm sorry, I'm looking at the time. We're running out of time. Just understand that it can be waived, but there are also ways to share that work product without waiver. There's such a thing as a common interest agreement, and cooperate, even in circumstances where you can make an agreement with the government to share your internal investigation without waiving that privilege. So just be aware of those ideas when you're talking to either your in-house counsel or your outside counsel as your investigation wraps up. And with that, Mike, I've left you all of 4 minutes.
Okay, thank you, Neil. I know it's a lot to cover. We did get some questions in. We probably won't have a chance to address all of them, but a couple of quick tips and takeaways, and then we will address the question to the appropriate presenter so that they can respond by email, if that will help. We think it's important just to remember overall, there's a lot going into making an effective investigation and a proper and legally protected one. But you need to have a plan. If you don't go into it with a plan, you're gonna not end up with the result you're gonna look for. You need cooperation, and that could be taking some cajoling. It could also take some time for that person to gain the trust of you as an interviewer. So recognize that situation and have your emotional intelligence really kind of help you lead the way there. You'll need them not just now, but in the future if this does go forward into a more formal investigation or even criminal or civil matter. Make sure that you get all the information you need now. Don't wait. I always like to remember that the word listen and silent are spelled exactly the same. They're just different, the way that their letters are enumerated. And so make sure that you are listening and being silent while listening, so you're really listening to what they're saying and can come up with the next best questions for that. And then be prepared, be professional. You're representing the company. Remember that is what's going on, and make sure that you document everything thoroughly. Finally, just make sure that there, as Donna mentioned, and I think Neil also, that you allow silence between questions. Silence can be the best way for the person to want to tell more. And the longer you remain silent, the more that they may want to, the more awkward it gets. Be sure to ask questions you already know the answer to. That lets them know you're informed and that they can't pull the wool over your eyes. And if you're talking, you're not learning. So these are some of the things we wanted to pass on. We hope you find this hour helpful. There were a couple of questions that we will address individually with you from the speaker. And we hope that next month you'll find time and interest to sign up for our free webinar. It will be on pre-employment screening and the difference between that and ongoing monitoring. We will have a third-party presenter, Alan Lasky, for Universal Background Screening to answer questions on the pre-employment screening side. Matt, any final takeaways?
Great. Thank you so much, Mike. And thank you, Neil and Donna, for being with us. And thank you most of all to everyone who is on the call today. Again, please be on the lookout for your webinar recording, your copy of the slides, and your CEU certificate. we have a quick survey after this webinar that we would love for you to fill out, just so we can continue to bring value to you and make sure that you're hearing about what you want to hear about. So please just fill that out. I will, this PowerPoint will share Neil's contact information, and those questions that did come in, I will make sure that those get to Donna or Neil, whoever would be most appropriate, and follow-up will happen after that. So with that, I just want to say thank you on behalf of Provider Trust, and thank you, Donna, Neil, and Mike, and thank you all for being here, and please have a great rest of the week. See you next month.
Thank you, Matt.
Thank you. There's